hear you. This system will notify you once you begin your broadcast. The broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. Thanks for joining us today. My name is Teresa, and I'm with BOI Reporting LLC. Today, we're going to be talking about the new Beneficial Ownership Information Law, or BOI for short, that will be affecting over 32 million businesses starting January 1st, 2024. We are a filing service company that focuses exclusively on helping small businesses file their BOI reports with FinCEN. We are not affiliated with FinCEN, and we do not provide legal services, and nothing in this presentation should be viewed as legal advice. Please send your questions throughout this webcast, and we'll try to get to as many as we can. Here's a brief agenda for our webcast today. We'll talk about what beneficial ownership information is in this new law. We'll talk about what the intent and purpose of the law is. We'll discuss the reporting requirements, including any exemptions. And then we'll talk about what the reaction has been from the industry. And then finally, what BOI Reporting LLC can do for you and what our process looks like. So what is BOI? We will get into more details later, but what BOI is a new law that will require reporting companies to disclose their beneficial owners and company applicants to FinCEN. So what is a reporting company? Generally, it's entities, LLCs, corporations organized in the U.S. or foreign companies registered to do business in the U.S. The next key term I want to talk about is beneficial owner, and that is one who either exercises substantial control over the entity or who owns or controls 25% or more of the ownership interest of the entity. And finally, a company applicant. It's important to stress here, this is only for entities created after 12/31/23. This does not apply to any entity formed before 2024. So a company applicant is an individual who files the document that forms the entity for a domestic reporting company, or the individual who files the document that registers the entity to do business in the United States for a foreign reporting company. So let's talk about what the intent and purpose of this new law is. So government agencies have long struggled with investigations and tracing the money with the individual behind the entity and the financing of those criminal activities. Criminals have used shell entities to launder money for terrorist financing, tax evasion, human and drug trafficking, counterfeiting, and acts of foreign corruption, harming the national security interests of the United States. U.S. investigations typically are time-consuming, requiring many hours and warrants to eventually get to who is behind this illicit act. And it's important to note, many foreign countries around the world already have in place beneficial ownership reporting rules. And also, this is something that states are starting to draft laws as well, so it's something that's here to stay on a local and global basis. So with the goal of streamlining investigations and national security in mind, a bipartisan Congress passed the Corporate Transparency Act of 2021, and part of the Anti-Money Laundering Act of 2020 included in the National Defense Authorization Act. So the CTA created a beneficial ownership registry within the U.S. Department of Treasury's Financial Crimes Enforcement Network, FinCEN. On September 29, 2022, FinCEN issued a final rule implementing the beneficial ownership information reporting requirement of the CTA, which is set to go into effect January 1st, 2024. FinCEN's database, known as the Beneficial Ownership Secure System, is set to go live January 1st, 2024. And so all entities that were created before 12/31/2023 must file by January 1st, 2025. Entities that are formed in 2024 will have 90 days to file from the date it was formed, and entities formed in 2025 and thereafter will have 30 days from when the entity was formed to file. So let's talk about what the ramifications are if you don't comply. Well, there are civil penalties of up to $500 for each day that the violation continues. And then there's criminal penalties with fines of up to $10,000 and or imprisonment for up to 2 years. And if in connection with another federal crime, fines may increase up to $500,000. So no one really knows how aggressive FinCEN's going to enforce these new laws, but they are responsible for other enforcing other laws such as foreign bank account reporting. And there is a litany of cases where FinCEN and federal prosecutors have used those similar rules and penalties to aggressively prosecute, so should not be taken lightly. So let's dive into the details and what a reporting company is and what the exemptions are from reporting. So a reporting company is basically all legal entities short of trust, estates, sole proprietorship, and some general partnership. So I'd say some, as some states have you file a document with the Secretary of State. And in those situations, it would be considered a reporting company. A domestic reporting company means any entity that is a corporation, a limited liability company, or other entity created by the filing of a document with a state's Secretary of State, Indian tribe, or U.S. territory. A foreign reporting company is an equivalent corporation, LLC, or other entity formed under the law of a foreign company, registered to do business in any U.S. state, territory, or tribal jurisdiction by the filing of a document with Secretary of State. So, for example, a UK limited company or a German GmbH registers with the U.S. Secretary of State to do business in that state, they would be considered a reporting company. So I'm not going to get into all the exemptions as there's 23 of them and they can get complicated depending on your facts. You may need a legal analysis to ensure you meet that exemption. But generally, exempted companies are entities that are already highly regulated by government agencies, such as banks, SEC registered companies. Also exempt are nonprofit entities under Section 501c3. So let's talk about the most encompassing exemption, the large operating company exemption. There's a misconception that this law in general doesn't apply to small businesses, but this really does hit small businesses the most. So for this exemption, you'll need to meet all of the following. You will need to employ more than 20 employees, full-time employees. You must have an operating presence at a physical office in the U.S., and you have to have more than $5 million in gross receipts for the previous year's tax return. So you could easily meet one or two of these, but you unfortunately will have to meet all three to be exempt. So for more than 20 employees, if you have independent contractors, those will not count for your full-time employees. And secondly, for the physical office, it cannot be a PO box. So many e-commerce businesses may have just a PO box and they will not meet this exemption. And then lastly, you could easily have $6 million in gross receipts globally, but if only $4 million is in the US, you will not qualify for that exemption. The other exemption I want to highlight is the inactive entity exemption. So this exemption, like the large operating exemption, is one that you will have to meet all of the elements. So you have to be in existence before January 1st, 2020. You're not engaged in an active business, is not owned by a foreign person directly or indirectly, whole or partially, has not experienced any change in ownership in the preceding 12-month period, has not sent or received any funds greater than $1,000 in the preceding 12-month period, and does not hold any type of assets, whether in the U.S. or abroad, including any ownership interests, stock, membership interests. So what will be going on these beneficial ownership information reports for the reporting company? So you will have to have the full legal name of the reporting company, any trade name of the reporting company, a complete current address. If the principal place of business is in the U.S., the street address is the principal place of business, and then all other cases, the address of the primary location in the U.S. where the reporting company does business. The state, tribal, or foreign jurisdiction of the reporting company. For a foreign reporting company, the state or tribal jurisdiction where such company first registers, the tax ID number, including EIN, or when a foreign reporting company has not been issued a tax ID number, a tax ID issued by a foreign jurisdiction is acceptable. So now that you may have determined if you're a reporting company, you'll have to determine who is a beneficial owner. So let's get into those rules. A beneficial owner is any individual who directly or indirectly either exercises substantial control over the reporting company or owns and controls at least 25% of interest in the company. So let's talk about that first one with substantial control. Essentially, this is someone that serves as a senior officer. So the company's president, CFO, general counsel, CEO, the chief operating officer, or any other officer who performs a similar function. And then has authority over appointment removal of any senior officer, so a majority of the board of directors. One who directs or has substantial influence over important decisions regarding the below list on the screen, which can be quite vast as you see. The other beneficial ownership is a 25% ownership interest. So this will include your very simple share or equity percentage in a corporation, or any member units you will hold in an LLC. So you can see on these slides that there can be complex arrangements or other types of structures, but a vast majority will be fairly straightforward. So let's go to a visual example and one with indirect ownership. So on the left, you can see Jane Doe and John Doe equally own ABC LLC. They will both be considered beneficial owners since they own 25% or more. So let's say Jane owned 80% and John was named CEO. They again would both be considered beneficial owners. So now let's say Jane owns 80%, but John is a silent passive partner, and Jane would be the beneficial owner and John would not be. So now on the right, what we're going to try and illustrate is how there are multiple reporting companies. And if Jane and John own 50-50 in ABC, they would also be the beneficial owners of XYZ as well, and therefore they will have to file two BOI reports, one for ABC and another for XYZ. So there are some exceptions as who is a beneficial owner. This will include a minor child, but a parent or guardian must be named until the minor becomes of age. An individual acting as a nominee, intermediary, custodian, or agent, or an employee of a reporting company that has substantial control or economic benefits are derived solely from employment status, and such person is not a senior officer. A creditor of a reporting company. So now that we've covered who is a beneficial owner, let's talk about who is a company applicant. And it's very important that you understand this is only for entities formed after December 31st, 2023. So some entities have been around for 20, 30, 40 years. So figuring out who has helped form those entities can be difficult. And so the rule will only require new entities formed in 2024 and thereafter to include who the company applicant is. And you have 90 days to file the company applicant from when the entity is formed. So a company applicant is essentially for a domestic reporting company, an individual who directly files the document that creates a domestic reporting company. And for a foreign reporting company, an individual who registers foreign reporting company with Secretary of State. So a company applicant or applicants in many cases may be employed by a business, a formation service, or a law firm. For example, there may be an attorney primarily responsible for overseeing the preparation and filing of an incorporation documents, and a paralegal who directly files them with the state office to create the reporting company. So in this example, the reporting company would need to report two company applicants, the attorney and the paralegal. So again, this is only for entities formed in 2024 and thereafter. So what is included on the BOI report for the beneficial owner and company applicant? So for every individual who is a beneficial owner or company applicant, you will need to have the full legal name, the date of birth, a complete current address consisting of the individual's residential address, a unique identifying number in the issuing jurisdiction from one of the following documents: a non-expired passport issued to the individual by the U.S., a non-expired document issued to the individual by a state, local government, or Indian tribe for the purpose of identifying the individual, a non-expired driver's license issued to the individual by a state, or a non-expired passport issued by a foreign government if the individual does not possess any of the above. And then an image of the document from which the unique identifying number was obtained. So what happens if information is incorrect or changes? Well, unfortunately, you'll have an obligation to update or be subject to the penalties I discussed earlier. In particular, if any report is inaccurate when filed and remains inaccurate, the reporting company shall file a corrected report within 30 days. This 30 days is also true for an updated report, and once there is a change in information on the report, you will have 30 calendar days from the change to file the updated report. And I note calendar as this is not a business day concept. So let's talk about what is a change. So a sale by a 25% owner is an obvious one. Similar if there is a death, essentially once the title under the state laws occurs is when the 30-day time period to update the report would start to toll. Other somewhat common examples may be when a minor becomes of age and are now named on the report instead of their guardian. Also, as you can see on the screen, if there are any changes to the driver's license or passport, such as a name change, address, or unique identifying number on such document changes. Also, if a reporting company meets the criteria for an exemption after they have filed, this meeting the exemption would be deemed a change with respect to information previously submitted to FinCEN, and the entity shall file an updated report. So in other words, if you had filed a BOI report with FinCEN because you had only $4 million in revenue, 21 employees, and a physical office, but you didn't meet the large operating exception, but now you have a year with over $5 million in revenue and still have the 21 employees in a physical office, and so therefore you'll meet the exemption, you will still need to submit the change. FinCEN said with respect to that, they will have a box we can check that notes they're now an exempt entity. So what has been the reaction? The general reaction has been overwhelmingly negative. In particular, the U.S. Small Business Administration said the proposed rule would be economically burdensome for small businesses. The U.S. Chamber of Commerce said it's concerned that the proposal may unnecessarily burden financial institutions without providing meaningful information to law enforcement. Transparency International, the National District Attorneys Association, the National Association of Attorneys General, the ABA, and various other groups also expressed similar concerns. So who is out there helping companies with this new law? Well, when Treasury was developing these regulations and the cost to comply, they calculated it would cost companies around $85 for a simple entity and up to $2,600 for more complex. Again, various trade groups and associations lobbied hard in comments to Treasury to say that was vastly underestimated. The struggle now is with who is helping companies comply. CPAs are best suited to help their clients, but a vast majority are steering away because under the current structure, there is a risk that advising or preparing these reports could be considered the unauthorized practice of law by CPAs, and many of their insurance companies are advising they won't cover or limit their coverage. As a result, a vast majority of accountants are not advising or filing BOI reports. Somewhat similarly, attorneys are ill-equipped and not staffed to effectively or efficiently assist companies in filing Therefore, they're only focusing on complex structures and exemption issues. FinCEN has said they are working on a chatbot to help companies evaluate if they apply for an exemption, but as of today, there's still minimal FinCEN resources that are guiding companies. FinCEN has admitted a lack of public outreach and education, and they have limited general or marketing funding and resources, which has created a lack of understanding in general. Yet they said they will fully be enforcing this. They also have most of their resources deployed in developing system BOS, which we have experience with FBAR filings and know the hiccups and struggles with that platform has had over the years. So we anticipate them to be very focused in rolling this out and putting in much effort to meet this large demand of over 32 million businesses filing this report. So with that being said, we're here to help guide you through this new law and file your beneficial ownership report for you. In our experience with FinCEN, this will be a complex rollout with many bugs in the system. There's a long history with FinCEN FBAR filing and problems with configuration, error messages, and other system problems. We know as a business owner, your time is valuable, and trying to figure out a new system to file this very crucial new document won't be the best use of time. We have the right team in place to navigate the new law and system and are working on building our internal secured system to be compatible when the API is released by FinCEN. FinCEN has acknowledged on their website that there will be third parties such as ourselves that will be filing these on behalf of business owners. Generally, our process is similar to FinCEN filings like FBAR. So after it is determined you are a filing company, we will quickly and securely collect the required information about your reporting company, and with you representing and warranting that the company information is true and correct, we then will prepare and file your report and send you a copy of the report filed with FinCEN. We are simplifying this process for you so you can have the peace of mind that you are compliant with this new law. So that was a lot of information, and I have a couple questions that I want to get through. So here's one. I have a disregarded entity, single member LLC. Do these rules apply to me? Yes. In short, what this question is likely referencing is that for U.S. federal income tax purposes and in the IRS eyes, that entity doesn't exist, but for state law and FinCEN purposes, it does. So these entities that may not have their own tax return, but rather are part of another return, such as a Schedule C or E on a 1040 or other IRS business tax form, you will still need to confirm if any exemptions apply, but that would be an easy filing in the sense you have just one owner. This can be common with many entrepreneurs in many industries, or in general, as many individuals form entities to limit their liability to run or hold their business and property. You will likely need an EIN for that entity if you don't have one. Otherwise, as the reporting entity needs to put down a tax ID. So let's go to the next one. Do you think this reporting will get delayed or pushed back? No. Unfortunately, all indications as of today is that FinCEN is committed to a start of January 1st, 2024. They already changed the timing for 2024 only for new entities, that they will have 90 days instead of the 30 days to file their initial report. So we will keep monitoring that and update you if any changes are to happen. Here is another question. Are trusts considered reporting entities? This is complicated, but FinCEN outlined that certain trusts, like statutory or business trusts that file a document with the Secretary of State or similar office, that those generally will be considered reporting entities. But trusts that are formed and protected under a court of law, those generally will not be considered reporting entities. And another question that has come in a few times, is this an annual filing? It's a great question. So this is not an annual filing. This will be a one-time filing unless a change, like we had mentioned earlier, occurs. So in a lot of cases, you might have to only file once, but for businesses that have any changes in ownership or any updates to information, they will need to stay on top of those changes to be compliant with this new law. So it looks like that's all we're going to have time for. Those were some great questions. I thank everyone who participated. and hope you all learned a lot more about this new law that is coming out. Please reach out to us for any questions you'll have. Our goal here is just to simplify this for you so you don't have to stress about it, and you can just focus on your business and what's important to you. So thank you, and we'll look forward to hearing from you.